Good afternoon. The Supreme Court en banc, during its session on December 3, 2025, acted on the consolidated petitions in the PhilHealth case. The Supreme Court, through the ponentia of Associate Justice Amy C. Lazaro Javier, unanimously ordered the return of PhilHealth funds previously transferred to the National Treasury in the amount of 60 billion pesos and permanently prohibited the transfer of the remaining 29.9 billion fund balance. The court, by a majority vote, also declared void Special Provision 1D, Chapter 43 of the 2024 General Appropriations Act, or the 2024 GAA, and the Department of Finance Circular Number 003-2024 for having been issued and implemented with grave abuse of discretion amounting to lack or excess of jurisdiction. Special Provision 1D authorized the return of the fund balance or the excess reserve funds of GOCCs to the National Treasury to fund unprogrammed appropriations under the 2024 GAA. The DOF issued Circular Number 003-2024 directing the transfer of 89.9 billion pesos to the National Treasury, representing the fund balance or excess reserve funds of the PhilHealth. In compliance, the PhilHealth remitted 60 billion pesos to the National Treasury in 3 tranches. The Supreme Court issued a TRO against the transfer of the remaining 29.9 billion pesos PhilHealth funds and the further implementation of Special Provision 1D of the 2024 GAA and DOF Circular Number 003-2024. The Supreme Court struck down Special Provision 1D of the 2024 GAA for being a rider, a provision not germane or related to the bill's purpose. The Constitution requires all provisions of the GAA to be germane to its purpose, to prevent surprise or fraud upon the legislature, and to fairly inform the people of the bill's subject. A provision is considered germane if it is particular, unambiguous, and appropriate. While Special Provision 1D is particular in that it relates to the unprogrammed appropriations in the GAA, the Supreme Court found the provision ambiguous because it introduced the concept of a fund balance, a term not defined in the 2024 GAA. The Supreme Court also ruled that Special Provision 1D is void because it impliedly repeals Section 11 of the Universal Health Care Act, or UHCA, and the sin tax laws. Under Section 11 of the UHCA, PhilHealth is required to maintain reserve funds up to a ceiling equivalent to 2 years of projected program expenses. Each year, PhilHealth must set aside part of its net income as reserve funds, and any unused funds must be invested so that earnings are added back to these reserves. If the reserve funds exceeds the ceiling, the excess must be used to increase the benefits under the National Health Insurance Program and to reduce members' contributions. Section 11 also expressly provides that no portion of the reserve fund or its income may be transferred to the national government or any of its agencies. The Supreme Court ruled that reallocating PhilHealth's supposed excess reserve funds through Special 1D and DOF Circular Number 003-2024 makes compliance with Section 11 impossible. These measures undermine the very nature of PhilHealth funds as pooled resources for social health insurance, hinder the UHCA's goal of delivering comprehensive and universal health care, and ultimately violates the people's right to health and to an affordable, sustainable, and accessible public health insurance. The Supreme Court stressed that Congress cannot repeal Section 11 through the GAA, which may only provide appropriations consistent with existing laws. It cannot amend or overturn substantive policy. Any changes affecting the UHCA, particularly PhilHealth's reserve funds, must be enacted through separate legislation. The Supreme Court further found that Special 1D contradicts the sin tax laws, which earmark specific percentages of excise taxes on sweetened beverages, alcohol, and tobacco products exclusively for the UHCA. The Bureau of Treasury must set aside these amounts for the UHCA's implementation, and Congress must fully allocate them to PhilHealth through the GAA. Congress cannot reduce, suspend, or withhold these earmarked funds. The Supreme Court added that while the state may adopt measures to improve the economy, such measures must not contravene what the Constitution itself guarantees: affordable health care for all Filipinos, especially the underprivileged. The Supreme Court also ruled that the Finance Secretary cannot, in any capacity, augment any item in the GAA because this power belongs to the President. The Supreme Court also ruled that the President did not commit grave abuse of discretion when he certified as urgent House Bill number 8980, now the 2024 GAA, which dispensed with the requirement of reading on 3 separate days and the printing and distribution of copies in advance. Except in cases of grave abuse of discretion, the authority to decide whether a certification of urgency is valid rests solely with Congress. In this case, Congress approved the President's certification to expedite the passage of the bill. The Supreme Court also denied the petitioner's request to determine the liability of the DOF Secretary for technical malversation and/or plunder, ruling that such matters are improper for resolution in this case. The only issue properly before it is the validity of the issuances and whether they were issued with grave abuse of discretion, amounting to a lack or excess of jurisdiction. The Supreme Court ordered that the remitted funds amounting to 60 billion pesos be returned to PhilHealth through the 2026 GAA. The full text of the decision and the separate opinions may be accessed on the Supreme Court website. Thank you.